me bring back in my guest, criminal defense attorney Daryl Cohen, and criminal defense attorney, former prosecutor David Bruno. Daryl, I'll start with you. The more I learn about this, I'll be honest with you. When I first heard that she said it was part of a book, I was a little skeptical. But the more I'm learning about this and I hear the conversation and see more of what was written and learn that there was 65 pages already in there, it was in an envelope addressed to her lawyer. These are the things that she's saying. It involves her father's in this manuscript as well. He's been dead for 2 years. She says it picks up after Eric dies, and she's already written a book about her life experiences regarding the death of her husband. Maybe, what are your thoughts, book or a scheme?
Do you know the old song, Dreamweaver? She's weaving the truth in with her story. She's prolific as a writer, but it's hard to tell when the truth, excuse me, wrong word, when the lies begin and when and if the truth begins, if at all. She's very good at what she does, but like so many people that have committed a crime, she's not as good as everybody else put together.
Interesting. All right, David Bruno, is she as crafty as she seems? Is she weaving in messages for her witnesses in the manuscript for a book? Or is this just a little literal license she's taking for a novel, her next novel?
Well, Michael, issue number one is going to be whether or not it's admissible. And the defense in that motion is making an argument that the letter, walk the dog letter, is attached to correspondence to the attorney, and that the attorney's name was on the letter or on the envelope. The government says that is not the case whatsoever, that it was found in a cell search in an area that they had a right to go into and a right to see. So question number one becomes, was it hidden? And one of the things that she says in the recording is that she wasn't trying to hide it, okay? So that is contradictory to the defense's argument about it's being secreted in an attorney envelope. Because if this gets in, even if it gets in and there's an explanation, the fact of the matter is she's going to have to explain it. There's going to have to be explanation. There's going to have to be argument. And it doesn't look good whatsoever, one way or the other, if it comes before the jury, in light of all the other pieces of evidence here, which could corroborate the state's case.
Daryl, what is the attorney's obligations? You receive a package. It was in an envelope marked for her attorney, hands it to the attorney. She comes to visit, gives it to her. You read it, and you're supposed to pass it on or whatever, and you kind of realize there's some interesting details in there. What are your obligations as an attorney? Can you pass that information through an attorney if, in fact, it was part of a scheme?
In my view, absolutely, unhesitatingly, unequivocally, I cannot. I cannot further a scheme of some sort of criminal intent. On the other hand, if it goes to me and to me exclusively, then I can read it. I make a decision as to how we proceed with the defense, whether we use it a little, a lot, or not at all, or never make reference to it. But as soon as I pass it on, I'm no longer the lawyer-client privilege person. I am now part of a scheme, in my view.
Yeah. David, I want to get your thoughts on that as well. Do you agree with Daryl? You received something like that from your client. And again, I would imagine if she's sending it to her attorney, there's been some understanding that she's writing some kind of book, right? She's not just giving you that out of the blue, but you see it and you realize that there could be some issues. What do you do?
Yeah, context matters, Michael, certainly. Under no circumstances would I give it to anyone else. I wouldn't act as a conduit. To my co-guest's point there, no, I'm not getting involved in any conspiracy. And then personally, what I think I would do is confront the client and ask some very tough questions to see if my ethical duties required me to withdraw. Because I am not putting my license in jeopardy for any client. I don't care how much they paid me. I don't care how important the case was, how high profile. If they're asking me to do something wrong, pass information off, and my ethical obligations, I would probably withdraw if I got to the bottom of it.
Yeah, I agree with you. That would be the first thing I would do. Finally, of course, the defense is going to claim that this should not be admitted at trial because it was in an envelope marked for her lawyer, and they should have known that. sounds to me like it's going to be her word against the prison guard's words. Any chance at all of the defense being victorious on that motion?
There's always a chance.
Yeah.
PFA, pick for mayor, there's always a chance. Do I think based upon the evidence, based upon the facts and the testimony? No, I don't think it's going to be excluded. Yeah. On the other hand, do they really need it as a prosecution point to prove that she murdered her husband? If they don't need it, don't use it, because there's always something called appeal.
Yeah, fair enough. You have to really determine whether you need this bit of evidence. I say it's pretty powerful stuff. I would want to put it in my case. All right, gentlemen, stand by. Time for a break.